Similar plea or application or prayer but different results or judgment from Supreme Court of India. My name is Dr. Prakash Somni and I belong to Center for Grand Challenges and Green Technologies, Applied Science Innovations Private Limited, Pune, Maharashtra, India. Now here we are going to discuss two similar cases or two similar applications to the Supreme Court of India, but Supreme Court of India has given two different results or judgments. And why this is important, I will highlight you in the last slide of conclusion. So out of the two cases that we are going to discuss, the first case is that of TV news anchor Rohit Ranjan and second case is that of Nupur Sharma. The case of TV news anchor Rohit Ranjan is something like this. He has played a doctored or altered clip of Congress leader Rahul Gandhi during a program on 1st of July 2022 on the television. As a result, he is facing multiple FIRs filed in various states of India. So he sought a relief from Supreme Court of India, and in his petition he has applied for quashing of FIRs or complaints or clubbing them together and transfer to one place for trial. Now on this, the Supreme Court, the vacation bench of Supreme Court headed by Indira Banerjee and J.K. Maheshwari issued a notice to the central government of India through the office of the Attorney General on 8th of July 2022, and Supreme Court restrained various state authorities from taking coercive step against TV news anchor Mr. Rohit Ranjan. Supreme Court has also ordered that the petitioner should not be taken into custody and there should not be any second FIR or thus no fresh investigation in connection with the same cognizable offense or incidents giving rise to one or more cognizable offenses. The order given by Supreme Court of India is very correct because it's impossible for the petitioner to approach various courts and police stations all over the country in respect of such FIRs or complaints filed in different states of India. So the present writ petition was filed under Article 32 against the violation of the fundamental rights guaranteed under Article 19/1/A, that is freedom of speech and expression, and Article 21, right to life and liberty. The second case is that of Nupur Sharma. In this case also multiple FIRs were launched in different states of India, and Nupur Sharma approached the Supreme Court of India. The court bench consisting of Justice Suryakant and Justice J.B. Pardiwala. Similar petition like that of Rohit Ranjan was made by Nupur Sharma. However, no relief was given from the court. In addition, an undesired comment or statement was made by the court that the Nupur Sharma is responsible for beheading of a Hindu in Udaipur. So we are witnessing two different cases with two different cognizable offenses, but they are approaching Supreme Court of India with the same application or similar application, similar prayer, similar plea, but getting different results or judgments from the court. The third case is that of Ketaki Chitale from Maharashtra. As we all know, the Ketaki Chitale shared a poem written by someone else containing the name as Pawar, and multiple FIRs were filed against her at different places in Maharashtra, and she was literally dragged from one police station to another. Although in this case the petitioner, that is Ketaki Chitale, has not approached to Supreme Court of India, the case is very similar. Although the offense is different, the case is similar, that multiple FIRs were launched in different states or different cities, here in different cities in Maharashtra, and the petitioner was dragged from one police station to another for the same cognizable offense. So, in conclusion, I would like to point out here that we are facing a fundamental problem here. Two different cases, similar cases at Supreme Court of India, same application, same prayer, same plea, but different results or judgments from the court. This is not fair and this is not expected from Supreme Court of India. Now the problem is that this is happening in India because it depends on how the judge see the case, how a particular judge see the case, what he thinks about that particular case, and based on his judgment he gives the order. So to some extent, how the judge perceives the case is important. In other words, the justice has become dependent on judge and it can vary from one judge to another. Now this is a fundamental problem because it is not expected from the judiciary. Justice has to be universal, whether it is for one case or similar cases, the judgment has to be same. Justice should not vary from judge to judge or court to court. So a similar application in the trial court, session court, high court or Supreme Court, the judgment has to be same or parallel. It should not vary depending upon the judge who is sitting and how he is understanding the case and how he sees the case. Thus, there has to be a mechanism or control or one FIR for one cognizable offense or crime in India, or clubbing of all FIRs into one. And this is possible only with digitalization. For multiple FIRs for one cognizable offense, the trial or hearing should happen at one place and the judgment should be given at one place, and the penalty should also be given only once. There cannot be multiple penalties for a single offense because of multiple FIRs in different states. Now this case is important because in today's world, digitalized world, particularly connected with social networking and other digital devices, one single incidence, one single crime can lead to multiple FIRs in different cities or different states in India, but the person should be tried only once.